We're going to start the next panel right now, and the next panel is a panel of our clerks, the clerk for the first WCA and the clerk for DOA. It is going to be incredibly informative, and this panel will be moderated by the Honorable Rita Young from St. Petersburg. Thank you.
Thank you very much. I'm so pleased to have our clerks here today. You know, I heard somebody say earlier this morning something about keyboard warriors, and they are keyboard generals of those keyboard warriors. They keep us in line and help us to make sure that all the information we need is where it needs to be when we need to put our finger on it. And I was talking to Julie Hunsaker earlier and said that, you know, computers are integral to the work that the clerks do. And I was reminded of a joke, and I'm going to tell you. There was a class, professional class in college on computers long ago when they first started being important. And one of the students said, well, should a computer be masculine or feminine? And he said, well, let's make that determination ourselves. So he divided the classroom into women and men, and then told them to decide whether a computer should be feminine or masculine. And they had to give 4 reasons for their decision. So the men's group decided that a computer should definitely be feminine. And their 4 reasons were, 1, no one but their creator understands their internal logic. Number 2 reason that it should be feminine is because the native language the computer uses to communicate with other computers is incomprehensible to everyone else. Number 3 reason, even the smallest mistakes are stored in long-term memory for possible later review. And number 4, the reason it should be feminine, is as soon as you make a commitment to one, you find yourself spending half your paycheck on accessories for it. So now the women's group concluded that computers should be masculine. And there are 4 reasons. Number 1, in order to do anything with them, you have to turn them on. Number 2, they have a lot of data, but still can't think for themselves. Number 3, they are supposed to help you solve problems, but half the time they are the problem. And number 4, as soon as you commit to one, you realize that if you just waited a little longer, you could have gotten a better model. The women won. Now, our panel is a group of 2 wonderful ladies here today. Kristina Samuels, to my immediate left, is the clerk of the 1st District Court of Appeals, and she received her Bachelor of Arts degree from summa cum laude from Ohio State University, and she got her Juris Doctorate magna cum laude from the University of Miami College of Law, where she was selected to join the Order of the Coif. She has served as staff attorney to the Honorable Charles T. Wells from 2006 to 2009, and to the Honorable Charles T. Kennedy from 2008 to 2014. Prior to joining the 1st District Court from 2014 to 2017, she was the staff attorney for the Florida Supreme Court. She's been the clerk of the 1st District Court of Appeals since November 2017 and is a member of the National Conference of Appellate Court Clerks. Very happy to have her here today. We also have Julie Hunsaker.
You should have led with me.
And she is the clerk of the Department of Administrative Hearings that handles both JCCs and ALJ judges. She graduated from Pensacola Christian College in 2006, and after several years of working for the University of Alabama in Huntsville, she came to the Office of Judges of Compensation Claims in 2012 as the office manager for the OJCC Clerk's Office. In 2021, she became the clerk of the Office of Judges of Compensation Claims, and in 2022 was made the clerk of the Department of Administrative Hearings. She works with both judges of compensation claims and ALJs, and we're very happy she's here today. Now, we have gathered some questions from various sources, and we're going to discuss those here today, but this is a working lunch, and we would like to have questions from all of you that are here today. If you have a question, don't feel like you need to wait until they've answered other questions. If you have an answer or a question that you want answered, please feel free to raise your hand, try to get attention, and we will try to get that answered today. So we'll start out. Does anybody have a question to begin with? Okay, maybe we'll spur some on. All right. For Clerk Samuels, what does your office do to kind of keep cases moving?
Well, we check in with the judges about their caseload in various manners. Every other week, I send them a report that sets out every case where the primary judge has not circulated an opinion within 90 days of the court conference, or any panel judge who has an opinion in their chambers for 30 days or longer. Each month, I send them a list of cases that have been pending for 180 days past conference or will reach that mark in the next 30 days. They also get a list of every case that's in their chambers in whatever capacity. Then our writs and motions folks help with this by anything that gets assigned to a writs and motions panel. If it hasn't been resolved in 2 weeks, they check in on it. So basically, the judges are going to be nagged by me or central staff frequently. So when you call to ask if your case has been lost or what's taking so long, about all we can do in the clerk's office is check and see if it's in a judge's chambers or with central staff. We can't do anything to rush it along, and I'm not going to pass along a conversation between you and me without the other side present to the judges, but just know that I am hounding them all the time.
Well, who on the court decides motions?
Well, workers' comp is special. When you file a motion, it goes to the workers' comp unit to do an analysis of the motion, and then it goes to either the chief judge or a panel of judges to decide it. In some other case types, there are some stipulated extensions of time, or central staff or I have some delegated authority to act on some motions for extension of time. But in workers' comp, everything goes to a judge.
So to what extent does the clerk's office screen filings for technical compliance?
We have been very fastidious about records. So thank you, Julie.
You're welcome.
That's the main place where there's confidential information that could be coming in here that we wouldn't necessarily know it was there unless Julie and her folks did a review. Also, if something's thousands of pages long, it's really important to have bookmarks and be text searchable to make it a usable document. Similarly, with appendices, we check those for bookmarks, pagination, text searchability, because those also can be hundreds or thousands of pages long. As a matter of practicality, I'm not doing much screening of briefs for technical compliance because we just don't have the manpower to look at everything that closely. And I figure a 50-page document, if it's got some strange formatting or no bookmarks, is not going to be as much of a hindrance to the judges as a 5,000-page document without that.
Do you work closely with the group of clerks that oversee the JCC appeals before they go to the judges?
Is that for Julie?
The first DCA group that reviews these when they first come in.
Well, I have a deputy clerk who checks for the formatting issues and communicates with Julie's office if there's any problem. But
Okay.
as far as substantive analysis, it's going to go to the workers' compensation unit to summarize and make recommendations to the panel of judges.
If a video or audio file comes in, how is that handled?
So the easiest way would be to mail us a copy on a CD or a thumb drive or something like that. Those are becoming common. We get them all the time. I think that there must be a way for those who are very tech savvy to store the video on some kind of shareable drive, put a link into your PDF documents and send that through the portal. Links do survive going through the e-filing portal, but I couldn't begin to give you instructions on how to do that.
How are cases assigned to panels?
Well, we have weekly and monthly panels. So any time-sensitive motions or petitions or even emergency appeals that come in go to a pre-designated weekly panel. We have the weeks covered for the whole year in advance. And the determining factor of to whom the filing goes to is who was on duty when it was filed. So if a motion comes in on Thursday through the e-filing portal, whatever 3 judges are assigned for that week will be working on it, even if working on it takes well into the future, or we're waiting for a response down the road or something. That way it's completely blind. The judges don't get to pick which ones they work on. They can't set a response for a certain time to have a different panel work on it. It's luck of the draw. You filers don't know who's on duty that week. You file it when you file it, and it goes to that panel. As for the cases, once they're ready for decision on the merits, the kind of ordinary appeals that run their course of briefing and then get assigned to a 3-judge panel, we do that monthly. As the cases become ready, we put them in a virtual barrel of cases. Workers' comp has its own rotation. So when my deputy clerk is ready to assign for that month, she picks the first workers' case out and gives it to Judge 1. And she picks the second workers' comp case and gives it to Judge 2. So again, the overarching principle is that the judges do not choose their cases. And even if they find a reason they can't hear the case after it's assigned, they need to recuse, or they're retiring, or going to the federal courts, whatever it is, the clerk's office has a substitution list that we use to fill that spot. They can't give the case to their buddy or anything like that. It's a list that we keep, and we try when we're looking for a substitute to not even tell the judge what case it is. Just, are you available that week for oral argument or not, kind of thing. So.
Okay. And Natalie, did you have a question?
I think you may have answered it, but I was always curious if, like, the judges were like, I'm particularly interested in this, or this has piqued my interest, and I would like to be on the panel. I mean, they don't have any interest.
Nope.
Otherwise, probably Judge Thomas would be on, like, every word.
Yeah. No, we take great care to make sure that that doesn't happen. The cases are randomly assigned. Workers' comp is on a separate rotation from the other cases because they do tend to be a little more work than your average criminal case or something, so we want to make sure those are distributed evenly, but no judge has, if it's her turn for workers' comp, she gets it. If it's not her turn, she doesn't.
I mean, distributed equally, as in they all get to feel pain of having to deal.
Yep.
Yeah.
So no one gets 3 workers' comp cases in a month and somebody else gets 1 or 0. But that being said, there's nothing that prevents the panel from knocking on Judge Thomas's door to get her 2 cents on a case.
Now that EDCA is gone, how do you update a service address?
When we are docketing, if you put an email address by your name on your filing, we use that as your service address. We add it to your basically virtual index card in our case management system. So filing something with your email address causes us to update it. If you don't have anything else due at the time, you could just send a notice of designation of email address. Also, our system now scrapes the Florida bar each night to check for addresses there, so you could update your address at the Florida bar. If you want to give us a call, I am comfortable adding addresses over the phone, but I'm not going to take one off unless I'm really, really sure that I'm actually talking to that attorney.
Okay. Now, as far as some just important issues to remember when you're practicing in front of the first DCA, do you have anything you would like to share? Maybe problems you've seen before or things that need to be addressed?
Well, for this one, I picked the brain of our workers' comp unit and a few of the judges, and for the most part, they only had nice things to say. A couple suggestions that could help when you're discussing an exhibit in your briefs. If you just call it Exhibit 59, the judges or the staff attorneys have to flip back and forth to remind themselves what Exhibit 59 is. So if you could give a little description, you know, the video from the parking lot or the medical examiner's report about the knee, something like that, when you reference the exhibit, it just helps the train of thought flow. Another one that I hear in all case contexts is if you're asking for oral argument, your request is better if it explains why oral argument is going to be helpful. Just a blanket request for oral argument doesn't really do anything. I mean, the court could grant it if they wanted to. So give them a little bit of meat to convince them why they need to have oral argument. Another thing is that, as a few of you maybe have discovered, voluntary dismissal is not automatic at the appellate court. If you file an appeal, the court can choose to hear it to the end, whether you really want to or not. So they don't have to grant voluntary dismissal. So just add that into your equation of whether to file an appeal.
Did everybody hear that?
And I'm not saying they won't acknowledge a voluntary dismissal. It's just that it's a decision by the 3-judge panel. It's not something you automatically get. And another one for my peace of mind, if you are the attorney at the trial court level or at the JCC level, and you file and someone files an appeal, you remain on that case. By the operation of the rules of appellate procedure, you are appellate counsel unless you file a motion here to withdraw or have some kind of order of substitution entered if it's appointed counsel. So if you don't want to be doing the appeal, please file a motion. Yeah.
For oral argument, it used to be that trial counsel would automatically be admitted to the counsel tables when that was happening, and then I think during COVID that changed and only someone who would file a notice in the appeal. Has that gone back or is that still?
We do not have hard and fast rules about who sits at counsel table. I had a judge once answer the question by saying, if you're at that table, be ready to answer questions. So I would recommend only appellate counsel, but I'm not going to chase off trial counsel if they're sitting there.
Any other questions? Should you file proposed orders?
No. Our judges, they like to draft their own. We don't need proposed orders.
Okay.
You could include suggestions in your motion, but we don't need a proposed order.
And the Bates numbering on appeal?
Cover page is 1. If you abide by that rule, you can't go wrong. So your appendix, your record on appeal, whatever it is, cover page is page 1. Because what happens is if you don't number the cover page or you put Roman numerals or something, the page number reader on the PDF reader doesn't match what's on the Bates number on the paper. And so one page could have 2 different page numbers, it appears to be, and to keep citations as clear as possible, just start with 1 on the cover page.
Okay, well, thank you so much. Any other questions for our first DCA clerk? All right, Julie Hunsaker, our clerk of DOA. What are some common filing errors that you see come in?
To start off, this is not just me. I pulled the state. To be clear, I'm sharing blame.
They put a lot of effort in this.
And it's little stuff, honestly. It's going to be nitpicky, and honestly, I'm probably speaking to the choir here, so spread the word. If it's hard to read or the sentence doesn't make sense, look at it before you file it. There's been a number of times we'll get a motion or a notice, and we're not sure what you want, and we can't do anything about it until you tell us what you want. Docket remarks in all caps, this is a me pet peeve. Please don't. We don't need yelling in the docket. Lowercase is just fine. I am working on that with the OJCC clerks as well. Sometimes it's lower, sometimes it's higher. We're going for consistency, but it's a lot of people. But we're all going to work on that together. Titling your documents, be specific. Don't just say notice of filing. What are you filing? Give us information to work with. It helps us when we're navigating the docket and looking for things. Check the appropriate boxes when you're filing your attorney fee data sheets. Is it a stat fee? Is it not? Is it hourly? Give us information. Make sure it's filled out completely. It slows things down when we have to call and ask for clarification or get you to refile. And those are kind of the biggies for us.
And I know there was a notation about not filing proposed orders. And the rules require that you file a proposed order if everything is agreed upon. But filing a proposed order on everything is not something.
Right. There's a few judges who do like proposed orders. I recognize that. But on a whole, if you are going to file a proposed order, put proposed in the docket remark itself. Otherwise, it shows up on the docket and says order, and then I open it up, and it's not an order. So just, if you're going to file proposed because you're being required to do so, just make sure it's titled proposed.
Okay, and computing time as
I don't
far
do
as-
it.
Okay, all right.
Short answer.
Well,
The
you
rules
just go
do
by
it.
the rules, right?
The
You
rules
just go
do
by
it.
the rules,
But this
60Q
isn't a-
6.109.
But just a word to the wise, they are slightly different between the appellate rules and the Q rules for workers' comp. The difference I see is what is day one. So it sounds like under the Q rule, if I issue an order today saying for you to respond in 10 days, tomorrow is day one. But under the appellate rules, day one is the next business day after the directive. So if the first DCA were to issue an order today telling you to respond in 10 days, Monday is day one. So you get an extra day here and there at the appellate court.
All right. Are there any issues for the clerk regarding private mediations?
The biggest issue is when we don't get a report. We don't know if the private mediation was held, what the results were. Are we done? Did it settle? Did it not settle? Just not getting a report is probably the biggest issue that we run across and have to track.
And the rule and statute has requirements regarding that. Stuart?
Julie, my view is when I settle a case as a mediator, if there's no pending PFP, the parties, either I or the claimant lawyer does not need to upload the agreement. What's the official word?
I am not the official word. Why not file the report, though? What's the drawback for not filing?
They just don't, they don't want the exposure to the public.
Well, the claimant has the responsibility of filing pursuant to the rules within 5 days. And,
If there's no pending petition,
oh, you're talking about on a voluntary mediation where
Yes.
there's no, well,
Voluntary is different, isn't it?
yeah.
Like, this is
Yeah, we're
required-
talking about, required mediations. But if you do have a voluntary, I would think that'd be a good guideline, to make sure that it is filed timely within that same kind of time period. Because I would think generally when you're doing voluntary mediations, you might be coming up on trials that are scheduled and you want to give notice as soon as possible.
yeah, again, there's no pending.
We appreciate that when you do that.
I think it's probably going to be different from division to division, too. What judge is going to want, what judge isn't going to want. Did you have a question?
The automatic pretrial generating tool on the mediation tab, is there a way to make that only fill in the DC's portion if you're the employer carrier's attorney and you need to prepare it because you haven't got one from the attorney?
Can you say that again?
So on the mediation tab, you put mediation,
Right.
it generates the.
You're generating the pretrial.
If I've only appeared as a DC attorney, is there a way to make it only fill in my portion? Because what it normally does is it defaults to filling in
Right.
information of the petition in the claimant's clause.
Right,
I've not the time.
right. I can look into that. Anything's possible. But then I go talk to IT and they tell me it's not. But I can write that down and see.
In the back, we have a question?
Yeah, I may be jumping ahead a bit further, but on the pro se claim, do you handle theirs as well as you handle their situations the same?
A pro se claimant versus representation?
Yes,
It's the same.
it's the same when they're filing the petition.
When they're filing, they don't have to e-file,
Okay.
but that's about the only difference because everything still goes the same way. Is that what you mean?
Yes, yes, yes.
Right.
Any question?
In terms of clarifying who's who for the docket and for all the parties, do you know if DOTA has any plans to add a servicing agent section instead of it just all being under carrier?
No.
Okay.
You're not the first person to ask that either. We don't differentiate. We make no difference between the different types there are. Everything's a C. Everything's a carrier. I don't see that changing too soon. And honestly, I won't even talk about legal. That's kind of programming problematic. To get, the more nuance you have, the more complications you have. So is it important enough that we need to do this or is it not? And that's just one facet. But at this time, no.
Any other questions? I know I was asking attorneys, if they would have any questions that we could incorporate, and one firm indicated that what is the big deal about Joe's Plumbing versus Joe's Plumbing Incorporated? Because they were getting notices of deficiency when settlements were supposed to come through, and on the settlement documentation, it said Joe's Plumbing, and on DOA, it said Joe's Plumbing Incorporated. And they were spending hours of time when they looked across all the firms in the state that were under their umbrella firm of clerks having to spend time doing that. So what about that?
That's a toughie. I work with a lot of different judges who have a lot of different ideas. My rule of thumb when it's coming across my office is the order is what's directing me to do something. So this is the judge telling me. What you're filing, that's between you and the judge. But what the judge tells me, that's the button we're pushing. And the biggest problem isn't just that you're missing ink. It's that they're wildly different. It's not small changes like ink or company or whatever like that. It's a different entity completely. That's the biggest issue. So when settlements come around, if it's supposed to be Sedgwick, but Gallagher's listed on the case, let's get that fixed before we get to where you're filing your motion for settlement. Let's get it fixed first. If it's small things like that, it might be the judge who's making that decision. But really what I see is bigger differences than ink.
And I think that has happened, that there are individual clerks who look at it and they know, I do what I'm told.
Right.
And if I'm told Joe's Plumbing, I will not do Joe's Plumbing Incorporated.
Right.
And that might mean maybe the judge needs to say, that's okay,
Right. It's up to the judge, but
and you're okay with that.
Yeah.
I just want to say the clerk is okay
I'm fine.
with that. But another example that I had just last week, we had a claimant who had filed against two employers, but it was Joe's Plumbing / Pink Lady Plumbing. And, we're getting, the case has been going for a year, and there were different carriers and those two employers, and then when we finally get it down to about trial time, they discover, okay, Pink Plumbing should be removed. And so I entered an order based on the motion to remove Pink Plumbing, and I was told by the clerk's office, no, you can't just remove Pink Plumbing. You have to remove
You can.
both of them.
But you're renaming the entity at that point. So
Right.
you're telling us
So you're
to
really
just remove
removing
Pink
and
Plumbing.
adding.
Right,
Right.
right.
So that's what you need to think about. They did their motion to remove this entity, but that put a little cog in the wheels because we needed to remove both employers and then they add the right one back.
Or if the order directs us to edit the existing entry to this, that's fine.
Okay. but again, I've told my clerks, we adhere to motions. We do what we're asked to do. We can't make up what you want on your case.
Right.
And so we need to be told specifically, you know, what you want removed and what you want added.
Best
And
rule of thumb is just always look at that case page and see who's listed now and what you want it to be, and then just be clear in what you want.
Very clear
Very
about what
clear.
you want.
In simple language, add, remove. Those are my favorite words.
Again, I agree with you. That, I have catered to that, you know, remove employer so-and-so.
Yeah.
Add employer so-and-so.
Yeah.
Not just change this, change that, you know.
If we start having to look at a case and we're not sure what is supposed to happen here, now we're making a judgment call, and I don't like getting into gray area like that. I want to do what you want us to do.
Exactly, exactly. Any questions on any line like that? Are there any things that you do with settlements that you think are issues?
Nah, you're great. I think it really just goes back to knowing who's on the case, who needs to be on the case. When you file your motion, you're not hung up on a simple thing like a name being wrong.
And what about, something about social security numbers and requests for
when
child
you're doing a request for
support?
child support, sometimes the request will come across our desk and it will be XXXXXX in the last four. Put the whole social in there, because sometimes what's provided initially is not matching what you're giving us later on, and we want to make sure we're using the correct information for the claimant when we're looking for child support. That is a protected document, so if you put the whole social, you can, if it makes you feel better, file it as medical exempt. It's protected, so it's not going to get released, it's not publicly viewable. Just put the whole social, it helps us go faster.
And on appeal, do not put the social security
We
number.
redact it.
But, and any new filings, I
Yeah.
mean, we're not gonna be sending documents to social security,
That's
so
the only
we
time
don't
I
need
want
it.
the social. Literally the only time. Yeah.
For claimants who don't have a social security number, is there a specific way that that is desired to be pled?
You can just say no social. That's fine. Just so that we know.
And when that happens, what do you do?
We'll do the name search. If we don't have a social to go by, hopefully the date of birth, the address that's provided, we have enough information to pull from the county or DOR and match it up and make sure that we're reporting the correct amounts.
Okay, and an issue also came up about attorneys leaving a firm. What happens?
Cases follow attorneys, not firms. That's kind of a common misconception. If you're on a case, it's going with you wherever you go. And if it should stay with your firm, then someone has to appear from the firm, do a substitution of counsel. The case will then stay with the firm. But in the OJCC, it follows a case. A case follows an attorney.
Same at the appellate court. If you don't want that appeal, you need to file
Yeah.
a notice or a motion. The rules have different provisions for both in certain circumstances.
Any questions at this point? Please feel free. And as far as ideas, you've said before, Julie, that if somebody has an idea, that you want to hear from them. In other words, if there's something that they see all the time,
Yes.
you can work on that.
Yeah, and I mean this sincerely. I've told this internally to our people all the time, but if your staff or you are doing something and you're hitting 5 different buttons when you could just have one button, call me, email me. I get the Ask OJCC emails. We take those sincerely. We'll take a look at it, see if it's possible, but if there's something out there that is going to make your life easier, tell me. I don't use EJCC like you guys do and your staff does. So I like information, and the more information I have, the better choices we can make with programming.
Same here. I'd like to know. We use external vendors, so I have less control than Julie, but I'll try.
So now, if they wanted to ask you, Julie, or tell you, you know, I've thought about this, and this is something we could do, is the best way to reach you through Ask OJCC?
Or just call.
Okay, so phone calls or
I'll
just
talk on the
email
phone.
Ask OJCC?
Yeah, that's usually
Okay.
the best way to get to me, and then just tell me I have an idea, will you reach out to me, or whatever. I'm happy to talk.
So if, attorneys who are appellate attorneys and their staff, same question, Kristina, if they have ideas like that that can help you, what's the best way to contact you?
Email or phone call is fine. Again, we use the statewide e-filing portal for incoming, so I can suggest things up the tree, but we don't actually program that. And the ACIS viewer is run by a vendor, so we do pass along your suggestions, but it's up to them if it actually gets done or not.
But you're such a good resource. I mean, you do this every single day, and you know what makes it easier. And so they're very happy to hear from you and implement ideas, and they have done so over time. And so it's very helpful when practitioners who know the business can reach out and let them know, hey, this is a good way to maybe make things a little bit easier. Any other questions? Well, I thank you so much for your kind attention and a wonderful keyboard warrior general.